Just go ahead and pretend I'm gaveling this in. We'll go ahead and get started with our meeting and start with, I gotta get my stuff up. Start with Brian's reports. Brian, do you want to start?
Well, do you want to do the minutes first? Just go in the agenda order.
Move to adopt the minutes.
Second.
Yeah, I'm like going off the top of my head because I'm pulling up our.
Actually, we need to approve
Roll
the minutes
call.
as revised, shown
As
in
revised.
the first
I
supplement.
move to adopt them as revised.
So, second.
Aye.
So with so then I will go ahead and move to. So the motion is on the table where we're going to go ahead and approve the minutes. All those in favor say aye.
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 Aye. Okay. Any abstentions? Any nays? All right, then the minutes are approved.
Thank you. Now I'm happy to do the executive director's report. I'm even happier not to really have anything to report. There's been enough going on the last few meeting cycles. The only thing I would say is that this is our first meeting without the Legislative Council in attendance.
Oh.
So I've got my ear to the ground. I haven't yet heard of an appointment of her replacement. Once I do, I will meet with that person and introduce us and talk about the relationship. It may be that they are too busy to attend many meetings, especially when they're standing up as the Legislative Council at first. So I think it's important we continue to have great attendance as we have, and I appreciate that. But we will be one short for a while. Other than that, I don't have anything to report. So that concludes that.
Thank you. So then with that, then we'll go ahead and move to the third matter on our agenda, which is the 2020 legislative program.
Yep.
Brian, do you want to go ahead and lead that?
Yeah, that's memo 2053. And it's a good news, bad news situation. The good news is things went as we were expecting with the legislative program, which was as good as it was going to get in 2020. The CPRA bills, as I explained before at prior meetings, were pulled due to the COVID situation. We're hoping on reintroduction next year, but we're not counting on it. We don't know yet what the 2021 will bring. The bill on trial court restructuring, AB 1984, got enacted and was signed by the governor. That's our big success this year. It's our recommendations that got approved. Good job, Kristen. SB 1305, Senator Roth, this was the revocable transfer on death deed bill, and it got stripped back to being just a one-year extension on the sunset date for the existing statute, again, for COVID reasons. And then the resolution of authority, ACR 173 by Assemblymember Gallagher, was approved with our deletions that we requested, which is nice. It's nice working with a leaner set of authorized topics. But that's also the basis for the bad news, which is I made a fairly significant error in working on that resolution when I prepared a bill draft for submission to Ledge Council. For reasons I don't know why, I included a topic that should not have been included for deletion. So the topic in our prior resolution, which authorized us to do the non-substantive recodification of the Public Records Act, I included that as a topic to be deleted in the resolution, and it was enacted in that form, so that was deleted. Fortunately, I think that was a harmless error ultimately, because our main work on that topic is done. We've approved the recommendations. We've concluded the study that charged us with preparing a non-substantive reorganization. We still have to work with the legislature on implementing legislation. We will need to update it to reflect legislative changes since we prepared our recommendation. And we have discussed the possibility of making non-substantive improvements to the index of CPRA exceptions. Fortunately, I think all of those remaining bits and pieces can be handled under our general authority to work on technical and minor substantive reforms. So the deletion of that, inadvertent deletion of that authority should not be an obstacle to the work that still remains to be done on this topic. And for that reason, I think it would be easier just to live with the error rather than try and correct it. Because I think if we were to try and correct it, it would just create confusion. People would be wondering, why are you reauthorizing something that we thought you were done with and that you deleted last year? So my recommendation would be to accept the resolution, including that inadvertent deletion as is, rather than try to pursue any kind of correction to it. Is that acceptable?
How do we know that it was an error, though? Oh, you guys are all
Well,
saying yeah.
because it wasn't something that was a commission decision.
No, I know, but I'm just thinking, how do we note for our records that it was just like, you know, how if you did a motion and you made an error, then you just would note on the resolution or our minutes that it
Well,
was
it's our
an error.
minutes here. Our minutes here would reflect
It'll be
that.
noted in the minutes.
Okay, so I think that's enough.
Right, since this is a dynamic area of law that's of concern to a lot of people, but in the future, we're not precluded from putting it back on, right? I mean,
Correct.
you can see in 5 years there may be a need to revisit these topics because everything keeps changing and everything becomes more electronic. So I just want to make sure that we'll have an opportunity to revisit the Public Records Act, because I'm sure that will happen probably in 5 years, if not sooner.
Yeah, there's no permanent bar. And also the authority that we had was purely technical authority. It was to prepare a non-substantive reorganization. So if we have reason in the future to do substantive work on the CPRA, then we would have needed a new resolution of authority anyway.
I think it's fine. And we have
Okay.
a motion. Everyone's okay with it, Brian, just
No
by
dissent?
show of majority.
Okay. That concludes that item.
Okay, moving along. So we'll go to item number 4, which is the state and local agency access to customer information from communications service
Oh,
providers.
you know, I went too fast. I skipped I should not have moved on to the legislative program. I skipped the second administrative memo, which is the new topics memo.
Oh, yeah, you know, I was looking for that too.
Sorry
Okay.
about that.
Let's go ahead and go back then. So out of order, we'll go ahead and jump back up to number 2, which is memo number 2020-52.
Okay, well, before the new topics memo was the commissioner suggestions. Are there any commissioner suggestions this time?
Richard, do you have any suggestions? I can't see. So.
Without
Yeah.
any suggestions today. Thank you for asking.
Can I ask if there's any update on changing to the California style manual?
We were going to look at that for possible change in practice at the end of the calendar year so that all of our 2020 materials are uniform.
I will try to forget about it until then.
Okay, me too.
All right.
Okay, so this is the commission's annual opportunity to review its workload and set its priorities for the coming year. As usual, the staff memorandum on new topics and priorities describes a lot of different topics. Some of those topics were assigned to the commission by the legislature. Other topics were included in the commission's calendar of topics at its own request. And still other topics were suggested to the commission by various sources, either this year or in the past. I don't intend to discuss every topic described in the memorandum. So if you think that a particular topic deserves some discussion, please plan to raise that topic. As the commission is well aware, its resources are limited, and it needs to be very careful about what it decides to do with regard to allocating those resources. The commission's traditional hierarchy of priorities is described at page 40 of the staff memorandum. And Typically, what the commission has done is that it gives highest priority to its legislative program. Those are the bills that are, the proposals that are ready for introduction in the legislature in 2021. Second priority would be the studies that were assigned to the commission by the legislature, particularly if they have a deadline. I don't think any of our current studies do have a deadline, but anyway, the topics assigned by the legislature are next in priority. After that would be studies for which the commission has a consultant's background study that it should take advantage of before the background study goes stale. And then the fourth level priority would be studies that the commission has activated but has not yet completed. And finally, the last level of priority would be new topics that appear to be appropriate for the commission to study. That set of priorities, that ordering has worked well for the commission in the past, and that's what the staff followed that scheme in making recommendations about what the commission should work on in the coming year. The staff's recommendations are summarized at the top of page 43 of the memorandum. So the first priority would be managing the 2021 legislative program, which could include a lot of bills because we have a lot of bills ready to go. They're itemized in the memo, and I can list them if someone wants. The second priority would be to continue to work on any of the studies that are close to completion, but aren't quite ready to introduce in bill form this year. Third priority would be to continue to work on 4 studies that were assigned by the legislature. One is the toxic substances, because we still have to do chapter 6.5 of the toxic substances work. Then there's the fish and game law, the trial court restructuring, and the state and local agency access to customer information from communication service providers. Then we would also recommend continuing the ongoing study on use of the Uniform TOD Security Registration Act to transfer a share of ownership in a stock cooperative. And then if time permits, study one or more technical or minor substantive issues on a low priority basis. And taking all those things together, there's not much room, but possibly there might be room to begin a modest new study on a low priority basis, such as the transfer of use restricted property on death, or a study of presumptively disqualified fiduciaries. After the commission hears from any member of the public who wants to weigh in on the commission's priorities for next year or future years, and the commissioners have had a chance to share their own views on what the commission should be working on in the coming year, then there are really going to be 2 questions for the commissions to decide today. First one is whether the commission agrees with the staff's recommended set of priorities, or whether the commission wants to revise or refine that set of priorities in any way. That's the first main question. And then the second main question is when the staff seeks introduction of the next resolution of authority regarding the commission's calendar of topics, does the commission want to make any changes to that calendar of topics? The commission's already decided that it wants to seek authority to study and recommend statutory reforms relating to emergencies, and that's as described in the memo at page 43. So the question will be whether it wants to make any other changes to the calendar of topics in addition to that one. And while that's basically all I have to say, the commission should keep those two questions in mind, and I think now is probably a good time to check whether anybody in the audience has anything to say about new topics and priorities.
And if you can, in the audience, please raise your hand if you want to be heard right now. We do have one hand up from Richard Calhoun. And now we have two, but I'm going to go ahead with Mr. Calhoun since he was first. And
Brian, you muted yourself.
Can you hear me?
Yes.
We can't hear you, Brian.
Yes, Mr. Calhoun.
All right. My comment is going back to the staff's comment on the state of probate court. And the staff is basically saying their perception is it's a lack of funding and enforcement of existing laws. On lack of funding, the reforms that were passed in 2006 needed 13.9 million. 9 million of it was to do accounting, which will do nothing. So if we're saying this problem exists for lack of $5 million, we have bigger problems. But I want to focus on the second thing, enforcement of existing law. If we're not following existing law in the courts, I think that's huge. And I think this commission should be looking at the root cause. And I would like to suggest that possibly one of the root causes, if you look at the motor vehicle code and the penal code, each section has a related penalty for violating it. If you look at the probate court code, there isn't a single penalty for violating a code. And a perfect example is a temporary conservatorship is limited to 30 days, but the code doesn't say what happens on day number 31. And so they go on for years. And you go to criminal court, and if we don't meet those timelines, the suspect gets set free. We have a huge disconnect, and I think that's a huge policy issue that this commission should be looking at. And I think it's pretty straightforward. I think you're just missing the boat. That's all I have to say.
Mr. Calhoun, it makes sense, and this is just me just kind of just sharing this. I do think, I do get your point in terms of the vehicle and the penal code. I would say that those are driven by statute, and there's not a lot of deference or even wiggle room for a judge to go ahead and intervene, and especially like for traffic court. But I do think that that's an important point, but I do think that it's not necessarily one for the commission to address. Would any of the other commissioners or Brian, do you have any comments to respond to for Mr. Calhoun?
No, I mean, it would be unusual for us to look at something as broad and deeply policy-oriented as imposing criminal penalties under the probate code or administrative penalty, any kind of punishment for breaches of the court procedures in the probate code. I think that that's the kind of thing that would probably be best to take straight to an advocate that can, determine whether or not there's it's feasible to try and pursue a reform like that.
And even to the Trust and Estates Bar, I think they would be a good resource for you, Mr. Calhoun.
Actually, they're opposed to almost all our reforms. They're the ones that are making huge money by having controversy. Right now, once you're conserved by a 3-minute hearing, your rights are taken away, and you have no judicial, you have no administrative recourse, and you have no civil course. I mean, there's no recourse for these victims. That's huge. That's like someone getting accused by a shoplifter and then being sent to jail and never getting to see a judge.
Mr. Calhoun, just for our records and for the minutes, are you affiliated with any particular group? Can you state that?
Yes, CEDAR, California Coalition of Elder and Disability Rights.
Thank you. you are with an advocacy group, and I do, that we recognize your appearance here, and your comments will be reflected in our minutes. I do think it's a good place to start. I think, though, that for the action, because our body isn't able to make actual decisions on policy and legislative changes. We are primarily charged with reviewing and studying changes to the current law that have been proposed usually already by the legislature. So I would recommend that you work with, continue to have your group address or visit other advocacy groups. And I do think that your points are well taken. And if we see you again, then we'll at least have met you and you've introduced yourself in this topic. But at this point, we're unable to make changes. But I would like to, we'll table this, and then I guess there's another hand that's raised, and then the commissioners are going to vote anyway on topics. So we'll table this, and we'll make a motion to whether to consider this or to take it up as a study. Okay.
Crystal, Commissioner Simpson has his hand up.
Yeah, just a quick partial response for Mr. Calhoun as well. I share our chair's view that this is not really the kind of matter that the commission takes up, the sort of fundamental public policy questions. I would suggest that maybe raise, because we have no independent basis for determining the nature of the problem in the first place that you're asserting, but we would have to do investigation to sort of figure that out. And that's not something that we as a commission do, but you might contact whichever policy committee in the legislature, both the Senate or the Assembly, that has jurisdiction over that, probably the judiciary committees, and contact their staff and share both whatever evidence you have of the kind of problems that you're describing and what you would suggest as a solution. And they may well have either members of their committee who have expressed interest in that issue, or other advocacy organizations that are similarly in line for sort of philosophically. But I'm not sure that that's really a function of this commission.
Thank you, Commissioner.
I think that in the new topics memo, we explained that both the Judicial Council and the legislature in the past 15 years have both undertaken comprehensive reviews of conservatorship law. And the Judicial Council just recently again established a new subcommittee to look into conservatorship law matters. And CEDAR, the organization that Mr. Calhoun is from, has successfully been introducing bills on the topic for the past few years. So it's just an area where, because the commission's resources are so limited, this is just not really appropriate for the commission to undertake a comprehensive study of conservatorship law at this time. And it doesn't really look like it's a problem that should be addressed piecemeal. If there is to be any work done on it, it would make sense to take a broad look, and the commission just doesn't have resources for that now.
And I would just also add to Mr. Calhoun that you would get, I think, faster action. Some of the studies that the commission takes on, they are years long. Whereas if you did have support with an actual either senator or an assembly person, then they would be able to help to move this within maybe a year or a year and a half, as opposed to our looking at a very broad view of whether there is an issue. I just think as in the interest of your advocacy group, that you probably would do better to see if you can help find a sponsor for, and then move through the regular resolution and introduction of that resolution as a new law or a new piece of legislation. I hope that's helpful, but we're going to vote as a group on whether or not the current pending list of priorities and studies is something that the commission wants to move forward on. And at that time, then I would invite any of the commissioners to present this as a topic that we'd like to include or to balance that at list as a priority, or not as a priority, but something that we could get to if assuming that we can manage the rest of the matters that we have on calendar. There's another person in the audience, Alex Graves.
Yeah, I'm going to enable him right now. Thank you, Mr. Calhoun. I'm going to turn your channel off. Mr. Graves. Okay, we should be able to hear you now, Mr. Graves.
Great. Can you hear me?
Yes.
Perfect. Well, thank you so much. Thank you, Executive Director Herbert, commissioners, and staff. I'm Alex Graves with AICCU. It's a little bit of deja vu. In the early 2010s, I worked with some of you while I was with another association on the UGAPSHA issue. So it's nice to be back and see some familiar names and faces. Again, I'm here on behalf of AICCU. We are the membership organization for over 80 independent nonprofit colleges and universities in the state. Our institutions are as small as, a couple hundred students to as large as, tens of thousands of students that are major, research universities in the state. Appreciate your consideration and time. As we outlined in the letter we submitted to you all, the issue of distance education is a long-standing issue, not just for private nonprofit colleges in the state, but for all California-based institutions, public and private, that is yet to be substantively solved. I would just like to add, I think the staff memo does a good job of outlining the issue. We know that SARA itself is not likely to be solved right now due to the reasons that were outlined in our letter in the staff analysis. But I think the question we pose and the issue we pose to you all as a commission for consideration is there a possible solution to the distance education complexities for colleges and universities in the state? For example, we outline SARA in our letter, but the broader issue around interstate reciprocity and distance education, there are 9 states that participate in SARA, but do so without the model legislation. They did it through, their state administration. And in talking, for example, with some other groups who have looked at this issue, those are states that could theoretically enter into other reciprocity agreements for distance education with California. And so, I think what we are hoping you will consider looking at is this question of, is there some type of model for California that can provide a means or mechanism to simplify this process to some extent and to simplify this issue for California institutions, because the complexity and costs of going state by state for each institution is easily in the tens of thousands of dollars, going state by state, multiplied by, a number of states, in addition to, full-time staff positions that just have to manage the regulatory complexities of the current approach for institutions. And so, to the question posed in your memorandum, I think the reason we feel that this could be a fruitful exercise for the commission, recognizing that prior legislative efforts on SARA specifically have not gained much traction in past years, is that, again, we're not necessarily asking the commission to solve the SARA issue itself, but rather to explore and see if there's a way to craft some kind of broader, more nuanced solution for California colleges and universities to provide a landing place for the state to start to enter into some kind of agreements that begins to consolidate with some states, those that can enter into parallel agreements, or those who may wish to find a solution with California, given just the number of students, right, and the population of the state. As I mentioned, there are 9 states that don't use the model legislation: Arkansas, Delaware, Georgia, Idaho, Montana, New Jersey, North Carolina, Oklahoma, and West Virginia. And I would also just add, and I'm just about done here, I appreciate your consideration, is that New Hampshire, which does use the model legislation, they, interestingly, this year introduced new legislation that would impose additional requirements on for-profit institutions, which seemingly runs counter to their own SARA statute. So it does seem that there are, at least some opportunities in some states that are looking at potential modifications to their own law, and would be really interested to see if you all, with the expertise you have, could find a means for California, again, to provide some kind of landing place for states, as they want to enter into agreements to do so with the state and help simplify this complexity for our institutions. Really appreciate your consideration. Thanks.
The chair recognizes Commissioner King. Victor, you're muted.
I'm sorry. Hi, Victor King. Thank you for your comments. Let me share with you my perspective, both as a commissioner and the general counsel for a university. I think your points are very, very important and correct. But also as a commissioner, I want to point out that we have very limited bandwidth this year. In addition to all the pandemic-related things and the plethora of other topics that we're looking at, and this is my personal view, I'm not speaking for the commission, I don't think we have the bandwidth this year to pursue it. But I do think we should pursue it in the next year's agenda. And let me just touch lightly on why I think that's so. The letter we received from the colleges organization is correct. It is a little odd that 49 states have interfaced with SARA and we haven't. And so that calls into mind, what are we doing and should we take a look at it? I'm in no way saying that we should buy onto SARA wholesale. And as you know, the number of states have varied from the verbiage of the law that most of the SARA states have adopted. But it merits looking at because we're an outlier. And by analogy, those of you who were here over a year ago on mediation confidentiality, California was an outlier in that respect as well, that we were literally the most wedded to mediation confidentiality of any of the 50 states. And that warranted an inspection of why. And it turned out after 3 or 4 years of analysis and discussions on the commission, we reaffirmed there's a reason why California was going to be an outlier, because we strongly, strongly believe in mediation confidentiality. And so there's something good about the journey, even if we wind up not joining the other 49 states in adopting SARA or SARA-like provisions. It would be worthwhile for us as a commission to understand why we are the one state out of 50 who isn't doing it. It doesn't mean we will necessarily recommend signing on to SARA, but it may generate the discussion and the reflection necessary for the legislature to do something differently. And that's in fact what happened with mediation confidentiality. We couldn't decide as a commission on a set of programs that would be acceptable to the public and the legislature, but then the legislature reacted by modifying the informed consent provisions of mediation confidentiality. And so there's something good about the fact that we studied it for 3 and 4 years, although no one could say that we created the final product for mediation confidentiality. There's no doubt that the final product that was created by the legislature was spurred by our 3 or 4 years of research here on the commission. So in response to what you're saying is a very important need, and it is kind of ridiculous that out of all the states, every institution that does online in California has to enter an agreement with 49 other states before they can make their online offerings. this is very much worth looking at. So I propose that we bring this back next fall. And here's the last reason why I think next fall would be a good idea. The arguments for why we need to be part of SARA and how we're very much an outlier in this new world of online education, those arguments are going to be much clearer after a year of this pandemic situation. So there's going to be more anecdotes, there's going to be more things that people can look at. And so we'll have a more robust discussion should we take up this topic a year from now. And we'll be able to see, what are the consequences of us being the one state in the nation that isn't signed aboard on SARA.
That's a really good point about how we're in the middle of a pandemic. Barbara?
I just want to make one sort of procedural point here. The commission in its calendar of topics is not authorized to study SARA or anything that would fall within this, no umbrella that would cover this kind of topic. So it wouldn't be possible for the commission to undertake a study of SARA in 2021. If it would want to study SARA or related matters, it would need to request authority to study those matters, and that would have to be done in a legislative resolution this year. That's if you wanted to study those matters in 2022, you would need to first get permission to undertake the study this year.
Yeah, I saw that from the memorandum, and so that's what I'm proposing, that we, I wasn't aware that the timeline would extend to 2022. I thought it might be possible for 2021, but I would be interested, and only speaking for myself, if the commission disagrees, I fully understand that. But I think we would want to start the wheels in motion to seek approval to look at this issue, because at the end of the day, that's why we're here. I mean, we do have some relationship with the Uniform Laws Act Commission. I mean, we're here to try to figure out how to make the laws of California work better. And again, in this area, just like in mediation confidentiality, there's something strange that we're an outlier, and it's worth exploring. So if other commissioners, if a majority of the commissioners agree, I would like to explore how we would ask for that legislative permission. And of course, if the legislature doesn't want to give it to us, that'd be another factor to consider. But let's see what we can do to get this on calendar for 2022 then. It's not an issue that's going to go away.
Just as a point of clarification, I'm going to just interrupt you really fast, Commissioner Simpson, and then definitely we want to recognize you. But Barbara, I think because of the pandemic, we do have some emergency authority. And because from what I'm hearing through Stanford Healthcare, we'll probably be in a pandemic or in this state of online education, probably not necessarily with education, but the stay-at-home shelter-in-place orders for probably another foreseeable year. So this is actually, it's a hot topic that I see not necessarily being presented as requiring authority based on SARA, but based on online distance learning. Just something to consider. And I'm not sure if that's, if the authority, if we have to be that creative or resourceful, but it's just something for us to consider, I think.
Yeah, my understanding is, and Mr. Graves can probably amplify on this, that with regard to sort of emergency steps dealing with the pandemic, that the various organizations like AICCU have managed to obtain some relief from the legislature to deal with the situation right now on a temporary, limited basis. But what they're looking to the commission for is a more permanent solution. Am I right about that, Mr. Graves?
Sort of. So the U.S. Department of Education did, during this pandemic, issue some temporary waivers at the federal level. However, there's still, our institutions still need to secure state by state authority through the normal process to serve students during the pandemic. And I would just add that, in my experience previously working with the commission, go into this recognizing that, a solution isn't crafted overnight. But I would just add that certainly the pandemic has really exacerbated and shone a light on the challenges of the current system, because we have just a hair under 200,000 undergraduates at our institutions, and 71% are California residents. But that means you have 50 to 60,000 students who are not California residents who are likely living elsewhere right now. And so if you're UOP, for example, in Stockton, right, and you have a student in let's say New Hampshire, and you didn't previously have an agreement with that state to offer distance education, and that student's now in New Hampshire, they need to scramble to go through this process, right, to continue to serve that student and offer their curriculum via distance education. We have, at least in one instance with one of our institutions, been made aware of a state issuing the institution a cease and desist letter because they did not have authority with that state to offer distance education. So really appreciate the consideration. And again, this issue and any review that the commission considers undertaking will hopefully extend beyond the conclusion of the pandemic, but the underlying issue remains.
You're muted, Crystal.
Barbara, did you want to just a follow-up question, and then we'll take?
Well, just one more point that I think the commission as a technical matter needs to take into consideration in these discussion of this topic is Commissioner King and Commissioner Carrillo and Commissioner Cubas all are affiliated with institutions of higher learning right now. I don't know how the conflict of interest rules would apply to them and to what extent you would be able to work on this topic, but I think that's something that we would need to look into.
I have no problem with you looking into that. I am a legal malpractice practitioner from 12 years of practicing law in a corporate law firm, and I am an educator, and I don't think there's a problem, but I have no problem with you looking into that. As I said to Brian, probably in my second or third year on the commission, when Brian had made a suggestion that we should never consult with our constituencies because that might be a conflict of interest, and there was a proposal made along those lines. I pointed out, well, the whole darn point of the governor appointing us to this commission is to bring to the commission our experiences, our networks, and our connections. I mean, why am I here? There's 300,000 other attorneys. I'm here because I'm a representative of a certain demographic. I'm a representative of a certain profession. I'm representative of a certain educational perspective. And that's true of all of us. So, I think the argument about conflict is, well, we're all attorneys and we've all been in mediation. So why did we touch mediation confidentiality? That's the analogy I see. It is not a point that I think needs to be discussed too much, that three of us are involved in higher education. I am not advocating for joining SARA, nor am I advocating for not joining SARA. That's not my perspective. But I am advocating for understanding the issue so that the commission as a whole, and the commission as a whole, a majority of us are not educators. The commission as a whole will vote on what the state will do vis-a-vis SARA. So I don't think that the fact that three of us are in higher education will necessarily tilt the analysis. After all, the staff does the analysis, not us. I don't think the fact that three of us are in higher education will have any negative repercussions whatsoever, just as the fact that all 10 of us were probably involved in mediation confidentiality issues and mediation in the past. And many of us are engaged in mediation right now and will be engaged in mediation in the future. That doesn't affect us either. So I don't think the conflict issue should be the reason we don't undertake this. And by you proposing that 2022 would probably be a better year, that gives us a lot of time to figure out how to ask for this legislative approval in a professional, calm manner. I'm not advocating that we do this under some sort of pandemic emergency authorization or pressure. Let's do this
King, I'm
slowly.
going to just interrupt you just as a point of order, and then so I'm going to. Commissioner Rubin, I see your hand. Commissioner, I think, Victor, your comments are great. Let's talk to them or speak to those points when we consider this, okay? But let's get Commissioner Simpson. Did you have comments that you wanted to add?
Maybe just a quick question for Mr. Graves. I'm not really sure I understand the nature of the problem. Is this a consequence of California's more rigorous consumer data protection laws, or is this something sort of independent of that?
Sure. Thank you for the question, Mr. Simpson. So I think where rubber meets the road on this issue is not necessarily on the consumer privacy laws, but consumer protection laws. Yeah. So essentially, SARA requires that the same set of standards apply to all institutions of higher education, nonprofit private, nonprofit public, and for-profits. And California law, as of a few years ago, has some very explicit requirements specifically for for-profit institutions that go above and beyond what is required of private nonprofit and our public institutions. So there is an inherent conflict in state law that makes California's ability to enter into SARA right now challenging, if not, impossible. Go ahead.
So this is a public policy trade-off between the nature of the consumer protections that California has enacted for students of different categories of institutions versus access by in-state and out-of-state students to other institutions. I mean, that's really what's going on here.
Right. It's a fundamentally a tension between California's belief and values in strong consumer protection laws, which in this case are manifested through our additional requirements regarding out-of-state for-profit institutions.
Okay.
And yeah.
Thank you.
That helps.
Commissioner.
Hello? Were you calling on me?
Crystal, your signal's breaking up. Well, her connection is getting reestablished. Commissioner Rubin, why don't you go?
I am here to be able to talk. I haven't, you're still freezing on me there.
Why don't you go ahead, Commissioner Rubin?
All right.
We can hear you okay.
Yeah.
All right, thank you. I'm sorry that we're having that concern. Since we're putting our bona fides out as to our education background, I'd like to just say a word about that, and then I have some comments to make with regard to what the speaker is suggesting. I've taught at 4 universities over 10 years in the Bay Area, courses which included courses involving constitutional law, for that matter. I also served as a trustee of my own college in Ohio for a number of years, having no longer doing that. But so I have some acquaintance with some of these educational issues. So I wanted to add myself to the galaxy of those who have put their bona fides out there as having some knowledge of the educational system, although I'm by no means any kind of an expert. I am inclined to favor the approach that Commissioner King is taking, which is to say that we should not be restrained by the fact that we have a pandemic going on now, which is going to, as you point out, Barbara, and as others have mentioned, is going to last for at least another year and possibly well beyond. The issues that we're looking at in this case are public policy issues that are of great importance to educational institutions. The fact that we are an outlier of all the states is of some curiosity. I think we should not be constrained by the idea that we may not have the possibility in the coming year to do a complete and thorough analysis of this problem, taking it further than we have already done so. But I don't think we should consider ourselves needing to put off that further investigation, as Commissioner King is suggesting, until 2022 or beyond. I think that is a position which we could take with many things that are going to come up in our work on this commission. And I have said this before, and I will be repetitive in doing it again, that we should not consider ourselves restrained from looking at issues which are within our province and which are legislatively related, even if we have not been given the initiative immediately by the legislature to look at them. It seems to me we can make anticipation of problems and issues that are going to come up, and I think we'll be rewarded by it as a commission if we do so. There is nothing in my mind that's wrong with being somewhat futuristic in our points of view. To the contrary, I think we do a service for the state, for the legislature, and for all those interested in looking at these issues as carefully as possible. And Barbara, notwithstanding your excellent report earlier, where you point out the priority structure we have, and I agree with you. I don't think we should find ourselves constrained to look at issues as the one this gentleman is raising, because it is important that we not inhibit individuals from coming before this commission with a feeling that they're not going to get some responsiveness from us when we have a little more flexibility than we have often, or sometimes, pardon me, exercised. So I'm making that general comment simply because I think we should be guided by those points of view. So once again, I like Commissioner King's formulation of this approach, and I hope we can take that approach. And if I am joining 3 others with educator background, so be it. I'm happy to do so. So I just wanted to make those comments, and thank you, commissioners, for listening.
Thank you, Commissioner Rubin. Commissioner King?
Yeah, let's try to move on here. So can I suggest that perhaps, Barbara, you come back with 2 timelines, what we'd have to do to get permission to tackle this in 21, which I'm sensing is not going to be possible at all. But a second timeline of what it would take to ask for permission from legislature to do this in 2022, and come back with those timelines for us to look at. And then the commission as a whole can explore whether or not to do it. Richard, there is one distinction in that this is really, and I want to defend Barbara on this point, this is cutting edge because we're not being asked to look at a currently existing statute. We're being asked to look at a public policy conundrum, why we're different from the other 49 states. It's much easier, obviously, when we're saying to the legislature or the legislature has told us to look at a specific statute to modify. I think we need to be very conservative here and to ask the permission explicitly for, ask the legislature explicitly for permission.
I'm going to call on Brian. I'm sorry, Commissioner Rubin. I'll get right back to you.
I'm happy to wait, give Commissioner Rubin a chance to speak before you call on me.
Okay, Commissioner Rubin, you have the floor.
I'm totally respectful of what you just said, Commissioner King. I think that we are oftentimes in a situation where policy considerations could potentially be involved in formulating our views and judgments about the things we take up here. And I'm completely aware of the fact that we should not get into policy issues of a controversial nature. That is not our role. Nevertheless, I think we can, within our own parameters as a commission, look at these issues without having to resist the idea of bringing them forward in a timely fashion. So that would just be my additional comment.
Very good. Brian, did you have a comment?
Yeah, I was gonna offer a proposal, sort of a counter to what Commissioner King suggested, which is that if the commission is interested in the possibility of working on this topic, perhaps we could bring back another memo for the November meeting where we lay out language that we could use to request the authority, and with the intent that we try to get a resolution enacted next year. And because concurrent resolutions take immediate effect on approval of both houses, they don't require the signature of the governor. We might be able to have, if the commission wants to do it after looking at the language, we might be able to have the authority in place prior to the end of the next calendar year. I think that might be a way to sort of split the difference of expediting authority question, consistent with the fact that we're already pretty booked for next calendar year anyway. And it would also give us a chance to see specific language rather than just, you know, thinking in abstract terms about working in this general area.
Looking to see if any of the other commissioners have any idea or any other comments to add. Don't see any comments from the audience. I think that I like what Brian has just proposed as a perfect solution, and it speaks to Commissioner Rubin's concerns that our hands aren't tied. I think it also speaks to our being able to not be necessarily married. And I would just caution just the new members that even though the agenda looks like it's pretty firm and set, we will get emergency legislation, or we will get the legislature asking us to please consider review of a topic that will automatically change the calendar as well. So even though we're just setting the initial calendar for 2021, does not necessarily mean that these are all the topics that we're going to be dealing with in 2021. I would imagine that we are going to be dealing with a lot of pandemic aftermath, post-evaluation issues that will require our approach and our resources to just study to see what are the issues. But if I can make the motion, then that we adopt Brian, or we ask the staff to simply provide us with guidance on how to review topics for 2021 that would also involve Sarah, or review of any, I guess, matter. That's a long motion, but
yeah.
Does anyone get it?
I would suggest just that the staff brings back authority language for inclusion in a resolution, and you can discuss whether you want to do that or not.
All those are in favor?
Well, let me add one wrinkle, which is my inclination is to try to use it in language that doesn't tie us to Sarah. Speak more generally about reciprocity and interstate distance learning, because I think Sarah may ultimately be a bridge too far, but there may be things that we could do in the area other than that.
I would expand it even, Brian, just to say, we just need to know what is the process for reviewing topics for just changing or seeking legislative authority that require legislative authority. What's the process? If we had a general memo on that, then it would give and provide leeway, not necessarily just for distance learning.
Yeah, well, certainly the memo can talk about, you know, the process of like seeking the authority. But, you know, with the commission's consent, I would like to include like some draft language on the issue that Mr. Graves' organization brought to us.
I think it would help also Mr. Graves and all of us, because I think, like Commissioner King mentioned, I would imagine that all of us have some connection to either our alumni associations, or, you know, some way we're connected to some institution of higher education. So all of us do have an interest, and I do think that the discussion on our memo of distance learning and the consideration prompting our request for the staff to consider what is the authority and how do we go about getting legislative approval. So use that topic, but make it expansive so that it doesn't look like we're just advocating for one particular issue. And I think, are we all in agreement, or can we just take a simple, if someone wants to recite or create a better way to make a motion, and then we can just approve?
Is the commission okay with what I suggested in terms of bringing back a memo on potential of asking for authority on this specific subject area?
I'm with what Brian just said.
But I don't like I don't want it to be this specific. I'd like it to be presented as a question that was raised by this specific topic, because I'm also concerned that we just heard from Cedar, and it really should not, you know, I think while it didn't necessarily trigger emotions or question from any of the commissioners, we should also give deference to people who do come before us and ask us to study a topic. And it would be important for all to know, what is the process?
Well, I can explain the process right now.
In writing, though, and in a memo, I think it's important.
But it's very simple. I mean, we draft language, we find an author for a resolution, they introduce it, and it's approved by both houses. That's it. We just need a resolution that author gives us authority to work on a topic. I don't think there's anything in that process that controls the commission's sense on the merits of different proposals that people bring to us. And with respect to Mr. Calhoun and Cedar, you know, there were substantive concerns, I think, about the commission being the body that leads an effort on reform of conservatorship law. That's different from what I'm hearing here, which is where, you know, there seems to be a sense of the commission that this might be an appropriate topic for the commission to do some good on the merits. So, you know, it's not a process issue, it's not a deference issue, it's more that in terms of picking the topics, it seemed like the commission was disinclined to work on conservatorship law. They were inclined to work on this law, but we don't currently have authority to work on this law. So we would have to establish that authority, and that requires a resolution.
Conservatorship law is different because the commission already has in its calendar of topics the authority to study the entire probate code.
Barbara, I'll use conservatorship as an example. My concern was for not discouraging the public to come before us to ask us to study topics. So I am in agreement with everything we did this morning. So please.
The only thing I'd add is that in terms of not wanting to discourage people from making suggestions, I agree with that. Our process should be open and fair and considerate.
And that's what my concern.
But the commission saying no, that just happens, you know, and if that discourages somebody, that's unfortunate, but, you know, we have to make a decision on which topics to study.
Commissioner Rubin, did you have a comment?
Yeah, I'd only like to say that I'm prepared to support whatever motion I believe Brian is going to recommend we put up. Nevertheless, I would suggest that we take your point of view, Madam Chair, and have it understood with any language that has to be used appropriately in any resolution that we're going to eventually agree upon, that we are open to these kinds of suggestions. I'm a little less concerned, frankly, and some others on this commission are, with the need to have to go and ask for new authority every time we look at a piece of legislation, which is already in statutory fashion, that we're looking to try to either modify, change, correct, or do something with. Maybe I don't understand it, and I am a new member of this commission, but I think I'd like a little more clarification than we've already been given as to how many times and in what places are we being asked each time we have something of this come up that we have to ask for more authority.
Okay.
As I have read the laws that pertain to this commission, and I'm not going to repeat them because we all know them, and I've reviewed this in an earlier session, I think we have authority that we don't always recognize we have. And so I don't want us to stumble on this kind of problem and prevent us from coming to constructive solutions which are helpful to the people who come before this body, as this gentleman has, and as others will in the future. That's just my opinion.
Okay, so it sounds like everything could be harmonized if the memo that we bring back in November includes a general discussion of the authority issue, like what is our authority, how do we acquire it, what are its boundaries, and then a specific discussion of what step might be required in order to have the requisite authority to work on this topic.
Yeah, I'm happy with that formulation, Madam Chair.
Okay, so we'll move with that. And then Victor, did you have a comment or?
My only suggestion that'd be two separate memos because they're really two separate topics.
That's fine.
With that clarification, can we have a vote on that question?
I don't understand. So we're going to separate those two topics? So
the two issues.
Authority?
I'm saying that there should be one memorandum about the historical and policy reasons for why the commission does work or doesn't do work on certain topics. That's in the abstract. and then a separate memo about what we're going to do about online education.
Okay, so that's a good motion. So I'll second that motion. Do we have all those in favor of having two memos that deal with topics and our history? Good, okay. Let's
Aye.
aye. Say aye.
Aye.
Are any nays? Any abstentions? Okay, so the motion carries.
Could I ask a question of Mr. Graves before we turn off his microphone? You mentioned the number of states who have adopted sort of idiosyncratic approaches to the issue, not a full embrace of SARA, but slightly different. Could you please email Barbara or me information about those other states, which they are, where those statutes are located, et cetera, because that's something we will definitely want to consider eventually.
Yeah, absolutely. We'd be happy to.
Thank you.
Very good. All right, so with that, then I think we've gone through agenda item number 2.
No.
Oh, no, we have 2 more
We're not done
motions.
with the memo yet.
No,
But I would also just like to be certain, is there anybody else from the audience who has anything to say about the memo?
I don't see any hands.
There's no hands raised.
Okay, then the other question that you have not addressed at this point is the list of priorities that are provided in the memo that I summarized. They're at page 43 at the top of the memo. And the question is whether the commission approves that list of priorities for the coming year.
Move approval.
Very good. I'll second it. All those in favor say aye.
Aye.
Any abstentions? All those who disapprove say nay. It's a consensus, Barbara. So number 1, and I'll just, as a point of order, I'll just go ahead and summarize the second question that you put to the commission, that you wanted us to move to, approve the resolution or change to the, okay.
I think that second question is to some extent what we've already been talking about and resolved with the questions about the 2 memos that we'll be preparing for the commission in November. So I don't see a need to deal with that one further now.
Because it addresses, the change to the calendar. Okay. Are you good with that, Barbara? Do you have?
Yes, I think now we've covered the whole memo.
Okay. No questions, and our audience is starting to thin out a little bit. Item number 4, which is state and local agent. Oh yeah, that's what we were trying to. State and local agency access to customer information from communication service providers, study G300.
That's mine. And the memo after that under the same agenda item is mine as well. I'm just wondering if commissioners have any interest in like a 5-minute break before we jump into this. This is going to be a substantive topic. I see a big thumbs up from Captain Nemo. Okay. Is that all right, Commissioner Miller O'Brien?
Yeah, did you guys want to take a 5 or 10 minute break? Is that what you need?
Let's just make it 5. We still got a few substantive memos to get through this morning.
All right. Okay. I'll see everyone back at, I have 10:39.
So around 10:45, let's say.
10:45, then we'll resume. Thank you, everyone. We'll go ahead. Okay.